Now, away from that, the leader of the Indigenous Peoples of Biafra, Nnamdi Kanu, has agreed to seek out, or rather an out-of-court settlement over charges tendered against him bordering on terrorism and treasonable felony. The lead counsel to Kanu, Alloy Ejimakor, informed the Federal High Court in Abuja as the trial of Kanu resumed in the capital city. Marvelous Obomadu tells us more.
The trial of the leader of the proscribed Indigenous People of Biafra, IPOB, took a different turn during the resumed hearing in Abuja. Counsel to Kanu informed the court of a possible discussion with the federal government to settle out of court. He said he had informed the federal government's counsel, Awolowo Adeboyiga, about the plan. However, reacting to the development, the prosecution counsel noted that it is not in his position to negotiate a settlement and urged the defense team to approach the Attorney General of the Federation for further discussion. Other interested parties in the case also threw their weight behind the decision by Kanu, calling on government to reconsider its position on the case and give room for national reconciliation.
Recently, we saw a situation where the Attorney General of the Federation took steps under Section 174 of the Constitution, which is very similar to Section 17 of the Federal High Court Act. He took that position to discontinue the prosecution of two very high-profile cases in this country. The first one concerning Wole, Yele, Showore, and the second one concerning Bodijo of Mieteala. So these things are not unusual. So if they do occur as a conversation in open court, it's just as a matter of course. So people might wonder why such situation should not apply to Nnamdi Kanu, and that is what played out in court today.
We can't go home most of the times. There's insecurity everywhere. People are being killed. Businesses are affected. Foreign remittance to our place is going down because people are leaving those rural areas. It's a matter of public interest and national interest that government considers this option provided under Section 17 of the Federal High Court Act and Section 174. And the ball is now in the court of President Bola Ahmed Tinubu government. As somebody who wants to renew interest, it's time to renew interest in the Southeast by opening the gate and let Nnamdi Kanu go home. And let's now open the conversation for addressing the challenges that led to this issue.
After ruling on other applications from Kanu's lawyers, Justice Binta Nyako urged both parties to meet and revert back to court. Section 17 of the Federal High Court Act and Section 174 of the 1999 Constitution permits reconciliation. It is believed that it's based on this section of the Constitution that the Attorney General of the Federation invoked his powers to discontinue and end the trial of Showore. And now many Nnamdi Kanu supporters will be hoping that this kind of arrangement be done for him. In Abuja, for News Central, Marvelous Obomadu.